What is a mediation of a Jones Act or Maritime case? A mediation is basically a voluntary process that both sides agree to do. It involves what's called a mediator. This is typically a lawyer who mediates cases. A lot of times it's retired judges. And what happens is you go in, most mediations last an entire day. Some of them will last a half a day only. For our Jones Act cases, we typically do them for a full day because it takes that long to go back and forth. But at the beginning of the mediation, the parties typically go into a single room. Very often the plaintiff, who is plaintiff attorney who's representing you, will give a little spiel about your case. He'll give a small presentation. Typically he says, this is what the case is about, this is what we think we can prove, this is the amount of damage that we feel we're entitled to. And then after that, the company attorney will typically give his presentation of the case. Obviously it's going to be very different than what your attorney has just said. This joint meeting usually lasts about 15 to 20 minutes, maybe 30 minutes in a more complicated case. At that point, the parties usually separate. They go into separate rooms. You will sit normally with your attorney for the better part of the day in that conference room, and the company lawyer go into an entirely different room away from you, and they sit in their conference room. The mediator will then go back and forth between the two conference rooms throughout the day, and he basically brings offers to them and settlement offers back and forth to you. If a number is reached, if you all can agree on a number, then a settlement is done at that time. The settlement money is typically received within 30 days. Sometimes it takes 60 days of that mediation date to get the settlement in. Usually it's 30 days though. The court proceeding is dismissed after that. There's no need to go to court after that point. There's really nothing more that you do if you're able to do a settlement at your mediation other than come in a month or 60 days later to get the settlement check, sign all the final paperwork, and your case is over with. If, on the other hand, your case does not settle during the mediation, your case just continues to move forward in the court process. Presumably your case has been filed in court at this point, which is when most mediations take place. You work your way forward towards the trial. What's very important to understand is that the jury is never ever told about settlement discussions during mediations. The jury is actually not supposed to even be told that a mediation took place or that the parties made efforts to try to settle the case. Another important thing to understand is that even if you were willing to accept, say, $100 or $100,000 at the mediation, the jury doesn't know about that, and the jury can still give you twice that or 10 times that amount if your case is worth that much. So you're not bound by anything that you were willing to do at the mediation later on in your case, and the jury is certainly not bound, or they certainly don't even know about the amounts and the numbers that were discussed at the mediation. So call us if you have any questions about the mediation process. It can be very, very beneficial to your case. We find a lot of cases can get resolved through a mediation because it's a good time to sit down for a whole day with the company and try to work out a good settlement.